Mr. Speaker, for those who are watching the live coverage of this high-rating, not terribly too late night show, either via television or parliamentary website, there is no need for them to thoroughly understand a recent Supreme Court ruling to truly appreciate the importance of this limitation bill. The Supreme Court's ruling is the latest development in long-running litigation by the Commerce Commission against Cat Harvey Limited relating to misgrading of timber prior to November 2003. The Supreme Court has confirmed that the Commerce Commission is subject to the 3-year limitation period in Section 43 of the Fair Trading Act 1986 when it brings proceedings for compensation on behalf of consumers. Now, the issue may sound a bit dry or remote, but is relevant to the limitation bill. But what does not sound dry or remote is the nature of the case. I guess the mentioning of words such as misgrading of timber or building material, etc., will hit the nerve or push the button. I will come back to that case, which is Commerce Commission and Court Harvey Limited at either committee of the full House stage or at the bill's third reading. Now, limitation law seeks to balance two interests. Firstly, people have the right to bring claims to court where they have suffered an injury or some loss as the result of wrongdoing by another party. The second and equally important interest is that we ought not to let the period in which claims can be brought run indefinitely. We shouldn't let plaintiffs sleep on their rights. The longer a plaintiff waits to bring his or her claim, the harder it is for the defendant to defend themselves, and the harder it is for the court to reach a good decision. Limitation periods allow potential defendants to get on with their lives without the threat of litigation forever lurking. This bill implements the Law Commission's recommendations to replace the current Limitation Bill 1950 with a new modern regime. The new regime will encourage claimants to make their claims without due delay and protect defendants from the unjust pursuit of stale claims. The Limitation Act 1950 is an old piece of legislation and it needs to be upgraded. The Labour Party supports the proposed changes in this bill. However, while Labour agrees with most of the bill, we disagree with the long stop period provisions. The bill provides for a long stop period of 15 years for most cases, but only 10 years for Building Act cases. The reasons for the shorter period in the Building Act, the complexity caused by multi-party building claims and fading memories, can also arise in other claims. So a shorter period is warranted. It should be 15 years for all claims. Owners of houses with latent defects should have just as long to bring their claim as those with other claims. The bill simplifies the limitation regime by providing a general civil limitation defense to most claims. A new concept, money claims, is introduced, which is defined to include any claim for monetary relief. This replaces the old approach taken by the 1950 Act, which sets out different limitation periods for different causes of action. The limitation period for most all claims will be 6 years after the act or omission on which the claim is based. There are exceptions or modifications to this period in cases of minority or incapacity, or if there has been an acknowledgement of liability, part payment, or fraud. A 3-year late knowledge period is being introduced because there might be circumstances where people don't realize that they have a course of action. Currently, the limitation period for most claims runs from the date the course of action accrued. namely the date on which all the elements necessary to establish the claim first came together. This has been very contentious and ambiguous. Under this bill, for most claims, the start date will be the date when the act or omission on which the claim is based occurred. The bill provides that the limitation defense can't be used in cases of child sex abuse, no matter how much time has elapsed since the abuse took place. There is currently no statutory limitation period for claims under the New Zealand Bill of Rights Act. This bill rectifies this situation, bringing the New Zealand Bill of Rights Act under the definition of money claims and the 6-year limit. The Limitation Act 1950 contains the general rules for determining the cut-off dates after which it is too late for a plaintiff to bring a civil claim. The most common period is 6 years and applies to claims founded on contract or tort, claims for an account, or claims in respect of a breach of trust. The current periods are subject to extension in a range of circumstances. For example, if the claimant is under 20 years of age, is of unsound mind, or because of fraud or mistake, the claimant was unable to discover that a claim exists. There are difficulties with both the substance and the drafting of the 1950 Act. The 1950 Act, which followed closely the terms of the 1939 Act, is incomplete, misleading, and inaccessible. Judges have suggested it is flawed and requires a complete legislative overhaul. The courts have made piecemeal attempts to cure the difficulties. The overall result has been a lack of harmony. One major issue with the current legislation is that in some cases claimants can be barred from gaining relief by the limitation period before they even know they have a claim. I look forward to more debate at the committee stage and at the bill's third reading. Thank you, Mr. Speaker.
Chester Borrows.